Good evening. Good evening, everybody. Welcome to the Johns Hopkins SAIS Dutch Alumni Chapter organized for SAIS Europe meeting. This is a conference seeing several interesting panelists discussing about Eurobonds and the decision of the German Constitutional Court in relation to the creation of this financial instrument. My name is Rachele Gianfranchi. I am with other three alumni, part of the Alumni chapter. We are part of the board. Since June, we have restarted and revamped a bit the activities with the great collaboration of the SAIS Europe. We have in the Netherlands about 185 alumni, of which 1/3 have been very active, and I thank you all for contributing with ideas, with speeches, with participation, with internship opportunities for the career track trips that takes annually place in several European countries. This year, it happened also in the Netherlands. Since June, the alumni organization has organized 5 meetings, and these meetings reflect a little bit the profile of our alumni and of the education that we have received at SAIS, because if I look at different topics, we have covered politics, defense and security, economics, and now the legal perspective in international relations. So this is really a pleasure to see different age and different professions coming together in the Netherlands with a similar background and similar interest. It's extremely enriching, and I hope that you will appreciate this conference as much as we appreciated the in-person meeting, which we hope we will restart very soon. I give now the word to the director of SAIS Europe, Michael Plummer. Michael Plummer is currently teaching international economics and Asian studies. And I regret not having been one of the many students you must have taught to in the more than 12 universities that have seen your teachings and your education. But it's really a pleasure to work with you, Director Plummer, and with the staff of the Bologna Center, which have been invaluable in guiding us and sometimes hand-holding, in my case, to revive the activity and to show and to attract also a new student population from the Netherlands to SAIS. Please, Director Plummer.
Okay, grazie mille, Rachele. To begin, I'd just like to thank the Dutch chapter for its continuous support of the school. And particularly to you, Rachele, David Hamburger, and for organizing this event tonight with such an impressive panel. Our alumni community in the Netherlands is growing, and I'm grateful for all of your efforts to build a SAIS community and to create opportunities to get together and benefit from stimulating discussions of cutting-edge issues. The school wouldn't be the same without the engagement of our alumni, and tonight I'd like to thank each of you for supporting our current students by providing internship opportunities and career talks, supporting our future students by promoting the activities of our recruitment office, and last but not least, by supporting the school financially. I'm very happy that despite limitations in our movement, we can get together in this virtual space. Obviously, we'd all prefer to be in person together, as Rachele mentioned, but hopefully we'll be able to do so before too long. I hope that you and your families are safe and healthy. This is the end of my 6th year as director of SAIS Europe. It's also been my 20th year as a professor here, and my 38th year as a Bologna Center alumnus. It's a long time, but certainly this year is one that I will not forget. But before talking about the 65th anniversary and other things, I'd like to take a moment to acknowledge some of the more tragic aspects of 2020, the COVID-19 pandemic, and the tragedy that is stimulating proactive international protests against racism in the United States and throughout the world. As you know, Italy was at the front lines of the COVID pandemic when it hit Europe. Bologna was spared the worst of the outbreak, but we went into lockdown with the rest of Italy in early March, and it's been less than a month or so since we've seen the lockdown begin to ease. In the classroom, we had to start virtual lectures within 24 hours of, 24 hours notice. So didn't have a lot of time to prepare for it. And at that point, we adopted a blended in-person and virtual platform at first, before eventually having to move to becoming completely virtual for the rest of the semester. The faculty of the Bologna Center adapted well to this change. Some of our faculty, like Eric Jones, were very much up to date on these things, but most of us had not taught a class using Zoom before. So it was a real experience, and they embraced it with enthusiasm, and the students were patient and understanding, which was great. It was heartbreaking when we had to lock students out of the building, but it was a victory of sorts when at our SAIS Europe commencement on the 23rd of May, we were able to allow the 50 or so students still in Bologna to participate in person at the event. They had to go through a thermo scanner that we now have at the school, wear masks and keep 2 meters apart, but they did it. And it really was quite an emotional moment. Now, from a distance in Bologna, we were really quite outraged and dismayed by the murder of George Floyd in police custody, almost immediately following the tragic murders of 2 African-Americans, Ahmaud Arbery and Breonna Taylor. We're incensed at this reckless disregard for human life. And it reminds us that it's incumbent upon us all to fight racism and discrimination in all of its forms, direct or indirect, conscious or unconscious. At SAIS, we're one community, one family, and a threat to one of us is a threat to all of us. And we need to come together to support those among us who are the most vulnerable. Moreover, the challenges of racism are not limited, obviously, to the United States. It's a global reality, included here in Europe and Italy as well. The core strength of SAIS flows from its diversity, its multicultural community, and a firm commitment to making the world a better place, which is an oath that we all should take. This has always been an important part of the Bologna Center mission, to educate students in a diverse, multidisciplinary environment, to grapple with complicated issues and work together to enhance international cooperation. 2020, of course, is especially important to us because it marks our 65th anniversary of doing this. The school has changed a lot since Grove Haynes opened its doors to Largo Trombetti in February of 1955. The Transatlantic Relationship, which was very much the most important theme at the time, it's still an important subject, but so are other global themes that we encourage students to tackle, from European integration, as we'll soon hear from our panel, but also cutting edge issues in Africa and in Asia. The dedication of our faculty and administrators remains exceptional, as Raquel mentioned, and the achievement of our students and the loyalty of its alumni are also clear indicators of the Bologna Center's enduring impact. But let me briefly give you a review of the student body at the Bologna Center. The class of 2020, which just graduated, of course, has been one to remember. In fall of 2019, we welcomed 176 master's students of 45 nationalities. So it's a very diverse group. And a bit over half of our students were US citizens, but of these, about 25% had 2 passports. And for the first time, we had students coming from Saudi Arabia, Afghanistan, and Cuba. 4 students were from the Netherlands this year, and 3 were part of our collaborative agreement with the University of Leiden. Our cooperative degree programs continue to be a great way to tap excellent students coming from prestigious universities, as well as serving as platforms for recruitment and diversity. This year, we've added a cooperative degree with McGill University in Canada and SAIS at the University of London. And they'll be joining our existence agreements with the Diplomatic Academy, the University of Bologna, Sciences Po Lille, and of course, the University of Leiden. I'd like to send an especially warm welcome to all of the University of Leiden students who have joined us this evening. As you know, this international diversity is the key to the success of our mission. We celebrate and encourage all aspects of diversity at SAIS Europe, which makes the Bologna Center experience so enriching and unique, both within and outside the classroom. And as I mentioned, we said goodbye to the class of 2020 on May 23rd. And I'd like to reiterate that it really was a special class that I will always remember for its resilience and strength in the face of an unprecedented world pandemic. They'll face the next chapter of their life, be it professionally or academically, in a world of uncertainty, but knowing that they can rely on a close-knit, passionate, and supportive alumni network in the world. Of course, we also have a new dean at SAIS this year, and he certainly has his hands full. Many of you know Dean Elliot Cohen from your time at SAIS DC, where he's been a professor for the last 3 decades. Even without current events and the COVID-19 pandemic, SAIS is undergoing a major transformation from the rejuvenation of the faculty to a rationalization of its concentrations and adapting to a radically different MA market. As we adapt to address these new realities, we are never deviating from our mission to prepare the next generation of international leaders to address the myriad challenges of the future. We look forward to welcoming the class of 2021 soon. Some of you have even joined us for this panel, and welcome. This coming preterm and fall, following JHU level guidance, all classes will be available in person as well as virtually for those of you who do not wish to or are unable to make it to campus in time. This year, we received the largest number of applications in our history, but we still need to prepare for a lower overall enrollment due to the COVID-19 shock. Our admissions team is working tirelessly in this period to enhance our yield rate and ensure that the SAIS Europe class of 2021 will be able to continue their studies uninterrupted and will not be disadvantaged academically at all. By the way, the class of 2021 includes 3 Dutch students, and 4 students will be coming from the University of Leiden cooperative degree. So to close, let me just say thanks to all of you who were with us last month for our virtual 65th anniversary alumni weekend. We obviously would have preferred to do that in person, but couldn't do it. But we were happy that we had up to about 600 plus alumni across 53 countries who registered to participate. And the virtual celebration was really a wonderful shared experience. And we hope to see you all in person next year. Hopefully things will work themselves out long before that. Before I leave the floor to tonight's panel, I want to mention some great news from Bologna. I'm delighted to inform you that thanks to the generosity of one of our Bolognese alumni, current Bologna Advisory Council Chairman and Johns Hopkins University trustee James Anderson, we were blessed by an unprecedented $10 million gift. The gift not only benefits the school directly in a moment of unprecedented need, but offers up to $4 million in matching funds to encourage renewed and new philanthropy towards critical areas for Bologna, our faculty, our students, our new programs, and in particular, a COVID emergency relief fund to help us navigate the immediate challenges posed by the pandemic. So if you're thinking of renewing your support to SAIS in one of these areas, you can make it both tax effective in the Netherlands, as well as immediately double its impact thanks to James's matching program. The history of Johns Hopkins started with a gesture of extremely generous philanthropy. Today, in that spirit, and thanks to one of our Bolognese, I ask you to rise to the challenge to secure a long life to our school and the next generation of Bolognese. Thank you again for joining us here, for being part of this community and contributing to our many efforts in the myriad ways that you do. I'm always humbled by the great generosity and by the resilience of our alumni community, and especially the Bolognese. Through your efforts, through our efforts as alumni, we're ensuring that SAIS Europe will continue to flourish and serve generations of students to come. So thank you, arrivederci e a presto. Okay, Rachele.
Thank you, Director Plummer. And I will now leave the floor to the panelists. David Hamburger, who will be our moderator tonight, is a former SAIS student and now doing a degree, completing his degree at the Leiden University. And he will introduce the speakers and the topic. Thank you, David, so much for having contributed during your stay in the Netherlands so actively and so inspiringly to the activities of the chapter. Please, go ahead.
Thank you very much, Rachele. That's very kind. And thank you also very much, Director Plummer, for joining us. For those of you who are at the event, at the end of last year, you'll know Director Plummer sort of welcomed in the 65th anniversary with us in person. And we're delighted you could be with us for the virtual session as well. Let me sort of use my prerogative as moderator to address just two very brief technical issues. The first is that we very much invite participation. We ask you to participate actively, and you can do that by using the Q&A feature that is at the bottom right of your screen. Importantly, that is not the chat feature. So use the Q&A feature at any time to send a question, and then the moderators will collate those questions, will compile them, and ask them at the end. I ask that when you do use the chat feature, just put your name in there and your affiliation so we know from whom the question is coming. Second brief technical point is we've had a couple of questions from people about whether or not this will be recorded for later viewing. The answer is yes. We intend to post this on the Bologna Institute for Policy Research YouTube page, so you can view things later as well. So with that out of the way, let me briefly introduce our four panelists. We're very lucky, as both Director Plummer and Rachele have indicated, to have four distinguished panelists with us today. First, we will be joined by somebody who needs probably to most of you no introduction at all, and that is Professor Eric Jones. Professor Jones, as you know, is the Professor of European Studies and International Political Economy at SAIS, and he's also a Senior Research Associate at ISPI in Milan. And Professor Jones today has kindly agreed to give us a sort of overview of the decision we'll be discussing. That's the recent decision of the Bundesverfassungsgericht, and then perhaps to share some thoughts on the domestic German situation as well. So having discussed the political issue and briefly outlined the case, we'll then be joined by Dr. Armin Kuivers. Dr. Kuivers is Associate Professor of European Law at the Europa Institute of Leiden. He was previously a researcher at Berkeley, at Stanford, and Hastings in the US, and also in Istanbul, and has also served as a visiting fellow at the European Political Strategy Center. His research focuses on EU constitutional law and theory, and also on the euro. So he will be speaking to us particularly about supremacy and the constitutional issues that are implicated by the decision. Then taking a step back from the law and moving into the realm of economics briefly, we're joined by Sylvia Mara. Sylvia is a PhD candidate in European Studies at SAIS. She's also head of research at the Algebras Policy Forum, and before that, she was an affiliate fellow at the Bruegel think tank and served in the Commission's DG of Economic and Financial Affairs as an economic analyst. And so we'll have a nice comparison and economic perspective, both on the policies being discussed by the Bundesverfassungsgericht and perhaps also now with response to the challenges faced. And then finally, we'll take a bit of a review of those two factors, the law and economics, simultaneously. Frederick Bewe, who is currently a PhD candidate at Leiden, will help lead us through that. Frederick holds an LLB from Hanover, an LLM in European law from the University of Leiden. And he recently participated last year in the European Scholars Program, where he co-founded a social media civic engagement program in anticipation of the parliamentary elections. And Frederick will be sharing with us his perspective, particularly on an area of research that is the center of his dissertation work, and that is the legal limits of fiscal integration in the EU. So with that, I ask Professor Jones to lead us in the introduction. Thank you.
Terrific. Thanks, David. I'm going to set a timer because these German constitutional court decisions are so exciting. I know I'm just going to keep talking forever. And you can tell my level of excitement is really low because I spent most of the day today puzzling through the Dutch cabinet's view on next generation EU. So I feel like I'm almost with you now. Look, what I want to do is just introduce this court case and give you a sense of what the court actually said, because it's really hard. It's like 200 pages long, and it's full of all this legal language. And I'm not a lawyer, so I'm going to give you the sort of boiled down Texas version of what the court was saying. The case doesn't revolve around Corona bonds or any mutualized debt instrument per se. Instead, the case revolves around what's called the Public Sector Purchase Program, which is the European Central Bank's effort to engage in what we in the United States call quantitative easing by buying outright assets, in this case, assets issued by the public sector, so government debt, by buying this government debt and then holding it on its balance sheet and giving central bank credit in exchange. Now, this is a nice way for the ECB to print money to generate a lot of liquidity, and it's been doing this since about 2015. And at about the same time, a bunch of conservative economists in Germany raised a complaint against this. And they raised a complaint that's based on two different issues that they had as concern. One issue was that this looks an awful lot like the central bank is actually financing states. So this is a kind of a monetary financing of government kind of issue. And the other is that this has real distributive implications. In other words, it creates winners and losers in a way that makes it look an awful lot like fiscal policy, which is the responsibility of the German Bundestag. And what these complainants were saying was that if it's interfering in the responsibility of the Bundestag, then in a way it's usurping our ability to vote for our parliamentarians and to be represented in the Bundestag. So it becomes a constitutional issue in that way. Now, this is a really long and complicated issue that wound its way through the German court system. And then the second chamber of the German Constitutional Court kicked it up to the European level in order to get the European court to rule on whether the ECB had actually operated outside of its mandate by doing these things. The European court said, no, everything is fine. And then the German court went back and said, well, we're going to look at this again, right? And so this ruling is them looking at it again after they'd gotten this interpretation from the European Court of Justice. Now, what they say in this ruling is really interesting. First, they say we're going to set aside the interpretation of the European Court of Justice because we can't make sense of it. It's internally inconsistent. And since we're going to set it aside because it's internally inconsistent, both in its own terms and in reference to previous European case law, we're going to have to force ourselves to understand these issues independent of what the European Court of Justice said. And in understanding the issues, I have to say that the German court actually touched on what I would consider to be some relatively reasonable economic considerations. Let me give you an illustration, right? So one of the things that it said is the fact of the matter is we're not sure whether this is monetary financing, but it looks a lot like monetary financing. Why does it look like monetary financing? It looks like monetary financing because under the public sector purchase program, national central banks buy the debt issued by their national governments and hold that debt on their books, right? So imagine the Bank of Italy will buy Italian sovereign debt and hold it on their books. And for the time that the Bank of Italy is holding it on their books, interest will flow in, right? Because the Italian government is going to pay interest on the debt, and the holder of that debt is the Bank of Italy. So then the Bank of Italy is going to receive this interest, and at the end of the year, it's going to put this interest in its accounts, and then if there's any money left over after they cover their costs, it'll hand this interest off to its largest shareholder. its largest shareholder is the Italian state. So essentially the Italian state is going to be paying interest into the Bank of Italy, and then the Bank of Italy is going to hand the interest back to the Italian state. So that looks a little bit fishy. It also looks fishy because what's going to happen is when the debt matures, then the Bank of Italy is going to take the money from the Italian state and then reinvest it back in Italian sovereign debt, right? And indeed, one of the things the court noted is after last September, it's not clear when they are going to stop reinvesting maturing principal in the debt that they hold. So now we've got a situation where 20% of Italian debt is parked in the Bank of Italy. That debt is being remunerated with interest that's handed back to the Italian state, and it's being renewed, right? So rolled over on an indefinite basis. It's hard not to see that as some kind of a monetary financing. There may be a legitimate monetary policy reason for doing that, but it looks strange. That's all the court really says. And then the court says, and then there are all these other things that the public sector purchase program has as implications. For example, if the central banks buy a lot of debt, then that pushes the price of the debt up. If they buy a whole lot of debt, it pushes the price of the debt up so high that the yield to maturity on this debt may in fact become negative, which means essentially that what they're doing is they're pricing the debt so high that normal people who want to invest in the debt would actually lose money if they bought the debt and held it to maturity. And not only that, but that's going to distort interest rates across the economy as a whole. And so all these people are going to lose money that are trying to save money. They're not going to be making money off of interest. They're going to be losing it instead. And so what the German court said is, we don't really know how to interpret this. We don't know how effective the monetary policy is relative to the cost that it's imposing on society. And we don't even know how to frame that question. And much more important, we are not sure that the European Central Bank has thought about the relative effectiveness of the policy in proportion to the losers that it's creating from the policy. And so there's a proportionality consideration that needs to be taken into account. Now, when the German court ruled on this, what the German court said then is, okay, well, now we've got two different issues that we don't really know how to judge. We're not quite sure that the European Central Bank is evaluating these things either. So what can we do? And the answer is, well, the German Constitutional Court cannot instruct the European Central Bank to do anything. As a matter of fact, the German Constitutional Court, in theory, should not be telling even the German Central Bank to do anything, because the German Constitutional Court speaks to other constitutional organs. So what it did is it said, you know what, we think this is the responsibility of the German federal government and the Bundestag, because they're the constitutional organs to whom we can speak. And what we're going to argue is that, and what they find, and I found this actually the most interesting part of the judgment, is that the German government has failed to protect the constitutional rights of the complainants by failing to provide adequate oversight over the decision-making that's made in the European Central Bank, right? Which is like, I mean, I don't know. I wouldn't like to be found that I violated the constitutional rights of my own citizens if I were the German federal government in the Bundestag. So if this is true, they argue, there's only one thing that we can do, and that is to get the German government and the Bundestag, the two constitutional organs that are responsible, to assert more effective oversight over the way decisions are made, right? And this is where the ruling actually gets really interesting, because what it does is toward the end, it says, there's one way to get out of this, which is to get the European Central Bank, or rather the governing council of the European Central Bank, to issue a new decision on the public sector purchase program. And in issuing that new decision, what they have to do is to demonstrate proportionality, that they've taken proportionality into consideration. And along the way, it would be nice if they gave us some kind of clear exit strategy for finishing off this program and not reinvesting indefinitely the principle of assets as they mature, right? So there's got to be an exit strategy somewhere, and there's got to be proportionality that's demonstrated somewhere. And the German government needs to request this from the principal actor that is responsible for advising the German government on monetary policy, which is the Bundesbank. And so the Bundesbank and the governing council of the ECB are supposed to work together somehow to come up with this new decision. Otherwise, the Bundesbank will have to withdraw from the public sector purchase program. And so it won't be able to purchase German sovereign debt anymore. And much more important, in coordination with its European partners, the Bundesbank would have to sell its holdings of German sovereign debt back into the market. So it would have to divest itself of the public sector purchase program. And just to make this interesting, they gave the governing council of the ECB 3 months to issue this new decision. Actually, but remember, they're not actually instructing the governing council of the ECB because they can't speak to the governing council of the ECB. So they're only instructing the German government and the Bundestag to make sure that somehow the governing council of the ECB issues this new ruling. Now, when you read the ruling in that way, it's immediately troubling because it's not quite clear how anybody is supposed to get out of this. It becomes even more troubling when you realize that not only can they not instruct the governing council of the ECB, but, and crucially, the governing council of the ECB is treaty bound not to listen to the German Constitutional Court. And I'll just leave it there because I really want to figure out how this is going to work out. And I'm so glad we have such great panelists to help us.
Well, Professor Jones, thank you very much for that rapid and comprehensive overview of what is clearly a complicated situation. Dr. Kuivers, some thoughts on supremacy, constitutional orders, and how we get out of this mess?
Thanks very much also for that very clear and intriguing introduction from a more economic perspective, because indeed we've landed in quite some difficulties. So basically, what do you do when you're in a situation where two people fight and both are right? Most of you who are in a relationship will know this, and it's very difficult, especially when you lack a formal hierarchy to solve your disputes, which is the underlying legal problem. So let me focus on 3 issues here. I've also set a timer because, like the previous speaker, this is the stuff that keeps me up all night, and Frederick can attest to that. Now, 3 core issues. First, the issue of supremacy as such. Secondly, the open questions that underlie this issue constitutionally in the EU, including the role that supremacy plays in a much broader sense. And then the underlying constitutional problems, the weaknesses in the EU fabric that it actually shows, namely the open-ended problem concerning the euro and economic and fiscal policy, and the underlying nature of the union as such. Because the reason these 2 courts are fighting is because they're trying to resolve some impossible political issues that should not be solved by courts. So I'll get to that in the end. Now, first 101 lesson in European law. There is one foundational rule of EU law, and that is EU law is supreme. EU law always trumps national law, any kind of law. Is it a rule of national constitutional importance? Doesn't matter, EU law trumps it. Is it your most sacred norm since 1252? Doesn't matter. EU law trumps. Any rule of EU law trumps any rule of national law. Why is that so? Because otherwise the system wouldn't work. You have to understand that for the EU, this is a rule of existential importance, because otherwise 27 member states could simply change the laws as they see fit. Now, the interesting thing about this rule, which has been in place since 1963, is that almost no constitutional court in the EU accepts it. All but one have said, yeah, we respect EU law, we will normally give it supremacy, however, ultimately our constitution is boss. And you can also see where these people are coming from, because this is their entire job as constitutional courts, to protect the constitution. So if someone tells you to please give up your sacred constitution, you're not going to do it. Now, the small miracle is actually how well this system has functioned over the past decades. Because by and large, they get along quite well, and they listen to most judgments. If there's a real problem, they silently ignore it. Now, why is this judgment so big? We now have an open conflict between the most important constitutional court in Europe and the Court of Justice. The German Constitutional Court has been a lead protagonist of constitutional rights and constitutional power in Europe. And you see that many of the other constitutional courts actually cite the Bundesverfassungsgericht. So it has a great leadership, and actually it's now taken to citing all the courts that have cited the Bundesverfassungsgericht just to show how important they are. They're also one of the most arrogant courts, and the tone of the judgment is absolutely scathing. So if you just want to read a very, very, very arrogant judgment, I would say go ahead and go for this one, even though it is quite long. Now, we have a clash between the most important court of a member state and the top EU court. Note, however, this is big but not unprecedented. This has happened before. In two previous judgments, the Landtova judgment in the Czech Republic and the IOS judgment in Denmark, Supreme Courts have said, we disagree with the Court of Justice, we're not going to follow you. Now, note, that's only 3 times in over 60 years. In addition, those were less important cases. There was less writing on it, there were more principal judgments, and the conflict just fizzled out. This is a biggie. Also because of the underlying importance and the courts that are involved. So it's not unprecedented, but it is pretty serious. It's serious because of the importance of primacy for EU law as such, and also because of the role primacy plays. As I just said, it is a foundational principle of the entire EU. So EU lawyers get extremely nervous if you tamper with primacy. Even though we knew that it was never really the law, it was the kind of founding myth of EU law. The problem of this judgment is that you have the most important court in a very open public way challenging that founding myth of European law. And the question is, what does that do? Also in a time of Brexit, in a time of rule of law challenges in other member states. Now, notice, by the way, that so far I haven't said anything yet about economic correctness or economic impact. And this is part of the problem. EU law comes to this from a purely legal perspective. And so I'll come to the economic part in a bit. Now, if you're going to challenge the founding myth, so God never had a son, Buddha never did anything transcendental, you're of course going to get a very powerful counter-reaction, which is what's happening in the EU law community right now. So the primary response from the EU law community to this judgment was outrage. Especially EU constitutional lawyers were just very angry and upset, and they don't understand EU law. The reasoning is wrong. The proportionality logic doesn't fit EU law. Everything is incorrect. Now, then we get to the deeper problem that both courts are actually fighting a very difficult political question. The two underlying constitutional issues I want to spend some time on. The first one is that when we created the euro, we made a pretty fundamental distinction between monetary policy and economic policy. So the European Central Bank has the exclusive power to conduct monetary policy. The member states retain the power to do economic policy. However, many economists will tell you that there is no such distinction between fiscal policy, monetary policy, and economic policy as such. So we have an entire legal construct based on a difference that doesn't really work economically. And now we have two courts fighting over the question how to divide economic competence from monetary competence. Well, how do you do that? That is not a problem that can be solved by these courts as such, which is also, as was indicated already, the German court is also in a difficult situation. Because the German court raises a very valid question, namely, European Central Bank, you have an independent mandate for monetary policy, we respect it, but what you're doing is de facto economic policy. And even if it's still monetary policy, you are affecting economic policy to such an extent that it should not be you who is doing this. And if you do it, you should take into account what the consequences are, because the German court is looking at the reality where German citizens are losing savings, are losing their pension funds. So this is a huge political problem in Germany as well. There's a very clear underlying political economic motive for the judgment. Now, the problem is that they basically ask the ECB, so do a proportionality assessment. But how do you do this? How do you assess as a lawyer 50 grams of lower interest rates versus 10 grams of more inflation? That is an extremely difficult exercise to make. It's very normative. It differs per member state. The answer will differ if you're Germany or if you're Italy. So courts are very hard pressed to make this decision. But so legally speaking, what the German court is asking is almost impossible. From an economic perspective, you fully get what they're after, and you get the almost, the heartfelt cry of please take into account the enormous economic costs you're imposing on the German economy. that German voters have absolutely no control about. Now, this entire problem with exclusive monetary competence and no economic competence is now coming to the fore again with the COVID bonds, with the entire restructuring of the euro. And politicians have basically not acted. After the financial crisis in 2008, 2009, there was a broad consensus that this needs to be improved. Well, the crisis faded, at least from the minds of politicians. We had new crises, immigration, Trump, whatever you want to throw in there. So they didn't solve the issue because it's hard, which meant that the European Central Bank had to step up, invest billions and billions and billions. We're up to 2.5 trillion now. So the European Central Bank is cleaning up after politicians not doing their work and now being attacked by the court, and the court is also doing its work, namely protecting the German constitution. That leads to an even deeper constitutional challenge, namely we still haven't agreed what the EU is and should be, right? The EU started as a project. Many of the founding fathers assumed it would magically transform into a federation at some stage, which was a bit of a mythical thinking. That never happened. But the EU is now trapped in the conceptual space between a confederation and a federation. It has deepened and deepened in terms of integration. The euro is an example of this half-hearted approach to integration. And again, both camps have a strong point. One camp saying, well, the EU should remain an international organization, or the EU should integrate more deeply. As long as you don't do that, as long as you don't have an answer to what the EU is, it's very difficult to settle these questions. Because what we now have is an open, formal hierarchy conflict between the Constitutional Court and the Court of Justice. Well, in a traditional federate system, the answer is simple. The federate court is supreme, federate law trumps state law on most issues, and therefore you should just listen. So no matter who's right, there is a formal hierarchy. In confederal systems, the answer is also simple because ultimately constitutions remain supreme. So you also have a formal answer. The EU is in the middle and has worked wonderfully well. It's a very intriguing experiment, and there's many benefits to not solving this question, but this is not one of those benefits. We've run straight into this constitutional open-ended question. I doubt this is the right moment to press it, though. If we would start a convention on the future of Europe right now, it would be a very nasty debate, and the populists would have a field day, and I doubt we would end up with a more coherent system. But how do you deal with the fact that you have this open-ended question at the heart of your system and then have to answer such complex economic questions as well in such a complex system? So the outcome now is that we have this formal conflict between these two courts. We don't know who to listen to. At the same time, we know that law doesn't like these kinds of open-ended substantive questions. The value of a judgment, the validity of a judgment cannot depend on whether you agree with it. Just imagine if every party could just say, Judge, nice judgment, but I disagree with your reasoning, therefore I do not feel bound by your judgment. That's not the way that law works. But this is what the German court is saying to Luxembourg right now, the Court of Justice. So the Court of Justice has to respond, the EU has to respond, even though the substantive points that they raise are indeed actually quite valid. And this is being recorded, so I'm going to go on record as an EU lawyer saying this. The Bundesverfassungsgericht indeed makes many a valid point, and we need some better answers. But the way they make them and the tone they make them in is extremely problematic for EU law. So let me leave it at that for now.
Thank you very much. Sylvia, do you want to maybe take us from law to economics?
Sure. So I think I would like to start by giving some numbers to put into context what we mean by proportionality and why this is really important, even like in terms of size. So the ECB currently has two programs outstanding in terms of quantitative easing and securities buying. There is the asset purchase program, of which the public sector purchase program is actually a component. And this is the biggest historical program that the ECB has outstanding. And then there's the new program that has been introduced in March, which is the Pandemic Emergency Purchase Program that has been devised as a response to COVID-19. Actually, after the ECB came forward with quite market unsettling remarks about whether the role of the ECB was to close the spreads or not, which sent the yields on the government bonds of the so-called southern Eurozone countries, Italy in particular, back to levels that we had not seen for quite some time. So altogether, considering also that PEP, so the pandemic program, has been recently increased last week by 600 billion more compared to the previous 750 billion. If we consider the whole package, we are looking at 900 billion purchases under PEP in 2020, plus the APP. So the overall envelope goes up to 1.2 trillion from, say, March till the end of this year. So it is really sizable. And if you translate this in terms of the effect that this is going to have on countries' debt holdings, and also the economic effect and the implied fiscal effect that this is going to have, it is really, really significant. If you take the example of Italy, for example, which clearly, given that the public finances situation is a key country to watch when it comes to this kind of programs. Once we make some assumptions about the path of the European Central Bank purchases across countries in 2020, even with some very reasonable, even conservative assumption, you will end up having the ECB holding 30% of Italian outstanding debt by the end of 2020, compared to some 20% that they're currently holding. And the amount of sovereign debt issued by Italy that the ECB would be buying in 2020 would be as much as 60 to 70% of the financing need of the Italian state in the year. So this is clearly something unprecedented in terms of magnitude. If you look at the height of QE in 2016, when it was first, it was started at the end of in early 2015, but then the peak was in 2016. If you look at the monthly purchases, we're talking about almost twice as much as when the previous wave of QE was at the peak. So this is just to give you an order of magnitude of how big this is economically and how important it is going to be for countries, both on the fiscal side and on the economic side. That is really massive. Coming to the implication of the judgment in economic terms on what the ECB can do today and what it might have to do in the future, I think the implications today really are non-existent for the ECB, in the sense that, as you were rightly pointing out, the German Constitutional Court does not have any jurisdiction on the ECB, cannot force the ECB to do something or not do something. So the ECB will just carry on with the program the way it's been doing until now. And actually, if you look at the implementation of the public sector purchase program in March and April, so after the announcement that this will be increased and after the announcement that PEP will be introduced, you actually see those purchases going, you see a number of elements that suggest the ECB is actually not doing anything to sort of ease the concerns of the German Constitutional Court, because in terms of length and proportionality, what we saw after the judgment has been an increase in the size of the program and a stretch into 2021. So this was not clear until last week. It was a question that was kind of hovering around in markets, whether the ECB would be willing to stretch this into 2021, whether this was going to be a real emergency program or whether this was going to be more of a recovery leading sort of prolonged assistance to the economy of the Eurozone. The ECB answered last week saying that this is going to be, feed into 2021 as well. So clearly not going in a direction of that the German Constitutional Court would probably wish for. And in terms of the geographical proportionality, which is one key aspect I'm going to talk about in a second, what we have seen has been a significant asymmetry, significant use of the flexibility that the ECB said they would be using coming into this new phase. Because if you look at March and April, about 30% of all the purchases have been Italian debt. So this is clearly more than twice as much the capital key, the Italian capital key share, which is sort of the number driving the purchases in theory, and also the share that Italy had in the previous program. So if you look at the stock outstanding before February, and you look at the geographical composition was actually very close to the capital keys allocations. So up to now, the ECB has lived up to that allocation rule, but it is very clear that in March and April, this wasn't the case. So Germany was massively underweight and Italy was massively overweight in the composition. So coming to the implications for the future, I think that this is very much a question for the Bundesbank more than for the ECB, in the sense that the Bundesbank, as someone was mentioning earlier, is really at the cross of EU and German law at this point. And so it's going to find itself in a very uncomfortable position if the German Constitutional Court in its due time decides and concludes that whatever action has been taken on the side of the ECB is not convincing enough in terms of the proportionality assessment. And if the German Constitutional Court were to order the Bundesbank to basically disengage from the program, that at that point, the German Constitutional Court would be declaring illegal in terms of its own assessment. Technically speaking, it wouldn't be a big problem, I think, for the ECB to deal with a withdrawal of the Bundesbank from the program, in the sense that the ECB can reshuffle the holdings that the Bundesbank has could be brought. I mean, the Bundesbank will have to sell its holding, but that is mostly German bonds, actually. So the rest of the program could be split across the other central banks according to the capital key share, or the ECB could decide to buy a larger share centrally, which would actually go in the direction of increasing the risk sharing of QE as it's currently performed. For those who are not like super into the rules of monetary policy in the Eurozone, and I'm apologizing because someone decided it was a great time to start some drilling work in the apartment next by. So guys, if you're hearing some background noise, it's not me. But just to clarify how this works, it's a program that is managed by the Eurosystem as a whole, but actually the purchases are carried out by each individual central bank. And as Eric was mentioning earlier, each individual central bank actually buys mostly its own country's debt. So the Bundesbank buys mostly German bonds, the Bank of Italy buys mostly Italian BTPs. But there is a share, which is 88% of the total, which is bought centrally by the ECB itself. And differently from the rest of the purchases, the risk on those purchases is completely 100% shared. So it is shared, is mutualized, like this is a pure mutualization, that's 8%. So technically what the ECB could do would be to increase the share that is bought centrally, and so move from a situation where mutualization is happening, but it's not really explicit, to a situation in which it is actually more formally and explicitly done. So technically speaking, I don't think it would be a huge issue, but the economic implication, which would be massive, would be at that point that Germany de facto would be out of the Eurozone, because the German central bank would no longer be conducting the monetary policy of the Eurosystem. It would be in violation of the rules of monetary policy that the Eurosystem is asking the Bundesbank to follow. And so by definition, it would be very difficult to see how Germany remains fully a Eurozone country when the German central bank is no longer implementing Eurozone monetary policy, because that would be the situation at that point. And so obviously this would have economic implications that are massive and are completely beyond the issue that we are discussing at this stage. It would be a completely different discussion, which goes back to the discussions that we had in 2011, when it was the south of the Eurozone that was at risk of being pushed out or exiting the Eurozone. So summing up, I think not necessarily the end of the world as a decision, but a decision with very, very dangerous potentially implication both on the political side, as you were mentioning earlier, and clearly on the economic side. And it does show that the way we are currently doing mutualization is not strong enough to withstand legal challenges of this sort. Because the way we are doing mutualization is through the central bank, but it's sort of mutualization by stealth in a way, borrowing from Walter Schelke's book, which was dealing with sort of a similar issue, even though it wasn't mutualization. So proper, genuine mutualization that everybody can agree upon and that is able to withstand legal challenges would require something different, both in terms of the primary legislation underpinning it, and in terms of the instruments that would be required. So in terms of legislation, I think it was very interesting to hear, and it is absolutely true, I'm 100% in agreement with that, the distinction between monetary and economic policy. But I think there is another one which is relevant, and that is the issue of financial stability. So financial stability does not feature anywhere in the European Central Bank formal mandate, but at the same time, it is basically the reason that has been driving the most important programs that the ECB has put forward starting in 2009 and then even more recently. So the idea of transmission of monetary policy is a monetary policy idea, but it has very deep, significant financial stability implication. So maybe bridging this gap between monetary and financial stability could be one way to go to reconcile this gap that we're seeing also between economic policy and monetary policy, with monetary policy being very narrowly defined in the way that we are defining it now. So this obviously opens a discussion of whether the treaty should be refined, whether the mandate of the ECB should be amended, how. I mean, obviously, Pandora's box in all possible ways it means. And then in terms of instruments, I think this would, the natural counterpart of this would be to have something which is really centralized, so mutual debt that the ECB can buy, instead of buying local, so to speak, national debt. And here, I think the initiative with Next Generation EU is a start, in the sense that what we are going to see is an increase of common issuance by the European Union tenfold compared to what we have seen over the past 10 years, because we're talking 750 billion compared to, say, about 70 billion over 10 years between 2010 and 2020. So that's a start. At the same time, the way this is being discussed right now is as a very, very temporary and defined in time and in scope initiative. So it risks to be a start that doesn't really lead us anywhere. So I think all these discussions, however, we should be having them all together, because they're all tied together. And just looking at one side, one angle of the question is losing sight of what the broader picture should be and what the real architecture of a functioning monetary union should ideally look like. And the drilling stopped miraculously. So.
Terrific. Well, Sylvia, thank you very much. And perhaps in the Q&A, we'll return to some of these thornier issues of the distinction between what you've mentioned, economic and monetary policy, etc. Frederick, do you want to lead us through your thoughts on the decision and on what it means for the intersection of law and economics?
Yes. So I think it puts me in a very difficult situation, because I had so much input and I have to sort of try to tie it together. And I hate to start by saying there's actually something in addition that we have to consider, what's called constitutional identity. And it's sort of, the absolute limit that is inherent in the Constitution. And sort of it's an argument that is brought forward by the German Constitutional Court. It was not so central in this specific decision, because shared liability was not a real issue in relation to the PSPP program, as we just heard. But it might lure in the background for future programs. If we have a mutualization of risk sharing, if we have shared risk, that might be a real issue that comes up. But sort of let me start by saying the idea of a constitutional system is of course that it is the highest norm, the highest rule of the land. And in Germany, because of the historic experience, we have something that's called the eternity clause, which makes it just very difficult to amend the constitution. And this is a tool that was used by the German Constitutional Court to limit EU integration and sort of identify clear obstacles to a more fiscally and more economically integrated EU. So I fully agree that we need a broader discussion about where the euro is heading, but it seems like on a constitutional level, this might be very difficult to achieve in Germany. And sort of that's the research I'm doing. And I'll start briefly by saying something about the decision and then sort of try to reach some broader conclusions. Now, if you look at the decision, I think one of the crucial elements is indeed the principle of conferral. You know, the idea that the EU can only act within the competences we give to it from the member states' perspective. So it's limited by the mandate that the member states give. And then the impossibility to enforce it is when it comes to monetary and economic policies. We can't make sense what is monetary and economic policy. It's just not black or white. You know, it's not sort of, there's a blurred line. Like economic policy has, of course, monetary implications, and monetary policy has economic implications. So it makes the job for the German Constitutional Court very hard to sort of rely on this idea that the EU can only act within the competences given to it. So you have to effectively avoid a competence creep, as it's called, so that the EU is doing more than it actually should be doing, but at the same time allow for enough political and economic freedom for the ECB, for example, to conduct its policies, because it's independent and there shouldn't be too strong legal control. Now, the German Constitutional Court, just like other courts, they came up with this ultra vires review. So to scrutinize from a national constitutional perspective what the EU is doing and to set sort of limits to in case the EU is going too far. And this is something that we see happening here. So we have two ultra vires acts. First, the judgment of the Court of Justice is partly annulled, and then we have the ECB's decision, which is partly annulled. And that, of course, triggers some concerns in relation to the viability of the program, as we just heard. If Germany is dropping out of this program, is it still part of the Eurozone or not? So it has major implications for the entire Eurozone. And this brings up the question, can actually a constitutional court address such an issue that has not just national implications, but also has, of course, an EU dimension to it? And I think one of the biggest problem of the decision is really the tone that is used, because, I mean, we heard it already a little bit, but just to put it into words, the German Constitutional Court says that the Court of Justice's interpretation is objectively arbitrary and is incomprehensible from a legal perspective. I mean, that's the biggest insult that you can issue probably to an independent judicial authority. So it's really a slap in the face. And we'll see, probably stemming from this, a fight between simply the both courts, the Court of Justice on the one hand and the German Constitutional Court on the other hand. And I'm not sure what is the proper way out of this. And let me share some thoughts on sort of the prospect. So where are we heading from this decision? First of all, it's important to stress this transitional period that we heard already about, because it indicates that the ECB is, in theory, able to run these programs if they manage to do the proportionality assessment properly. So from a legal perspective, it's actually sort of confirming that the ECB could run these programs in the first place. And I think it's very important to stress this. The German Constitutional Court could have also just declared this entire thing completely unconstitutional, and thereby sort of say that the ECB can never run in the future such programs. So I think there's also a positive spin to it. But what it leaves us with is really this challenge, like how do we reform the euro in a constitutional sound manner? And I think democracy is really the main problem in this regard, because the German court emphasizes that the German parliament has to control everything. That's what we heard already. The Bundestag has to be in control of the budget. And if you have the central bank running a program that is more than 2 trillion big, and now we heard for 2020, it was 1.2 trillion in addition of bonds that are actually acquired by the European Central Bank, of course, you have to ask yourself the question, okay, but what happens if it goes wrong? Like, who is going to pay for this if something happens? And that's a concern that the German Constitutional Court raises here. And I think it's a question that we have to address, but I'm not sure where it's going to lead us. You know, I really feel that the dimension of a more integrated fiscal space in the euro is something that is very difficult to achieve from a democratic perspective and would really require to reconceptualize our national legal system and really fully integrate it into the EU legal system in order to achieve a shared space, and not just an EU space on the one hand and a national constitutional space on the other hand. And there's also a reason why the current discussions didn't lead anywhere, simply because it's constitutionally very difficult to achieve. But I think you can also read the decision of the German Constitutional Court as an invitation to fundamentally reconsider this, because the German Constitutional Court also stresses in its decision that the European Central Bank is almost in an impossible situation, because the political level is not acting, so it has to jump in and do something that it should actually maybe not be doing in the first place. But it raises the question, like, okay, to what extent are maybe the political leaders that are not finding the reform steps necessary also sort of responsible for the program that's happening here? And I think it can be read as an invitation to think more broadly about how to restructure the euro and how to achieve a space that is also governed or in line with national constitutional concerns. And just to add another dimension, the PEPP program, we heard already that it was going to be initiated, and we know already at this stage that this again will be challenged in front of the German Constitutional Court, simply because the standing requirements are so low. Every individual that is entitled to vote can initiate a procedure in front of the German Constitutional Court challenging these sort of programs. This raises another concern. If you have almost 60 million German voters that could theoretically proceed in front of the German Constitutional Court against a policy that is made by an EU institution, you could ask yourself whether this is the right tool or the right way to actually, stimulate a discussion, let's say constitutional discussion at the European level. And I think that really sums up my thoughts. I feel it's constitutionally, democratically very difficult to integrate the euro more under the current setting, because we have these strong constitutional limits that are framed as constitutional identity concerns. And at the same time, we know that we have to stabilize the euro or secure the euro, because otherwise it's just not viable. So, it really is sort of, it's between a fiscal hard place and a constitutional rock, like where are you going to navigate if you have to do something that's actually impossible? But maybe that's a good start to open the discussion. David, back to you.
Terrific. Thank you very much, Frederick. Well, I think that is a good place to start. Because we've had a number of questions about, well, to what extent is this type of fiscal integration even possible, especially in times like this one? So perhaps a question for all of you is sort of, if there's been a progress through muddling through, how far are we on the road where we can no longer muddle? Where will we have to ultimately make that decision? And is it possible to see a way for fiscal integration to actually be the solution to this problem?
Who should start? I don't know. Maybe I'll just say, sort of reiterate what I just said. In the Lisbon decision, the German Constitutional Court said that decisions on revenue and expenditure are central to German democracy. German democracy is covered by the eternity clause. Through the Euro crisis, we saw the emphasis on the German parliament has to control spending, has to be in control of the German budget. So I think from that perspective, the constitutional space in Germany is rather limited if you require the German parliament to control the budget. Now, what I could imagine is a way forward where you say, okay, the decision on the budget has to be taken by the German parliament, but maybe not necessarily in Germany itself, but maybe we can find a way where the German parliament can also act at the European level, so that we have sort of a shared space at the European level to take such decisions. I think that will really push the envelope and sort of establish a more constitutionally sound way forward to say, okay, fiscal integration, yes, but we need to think what is the role of national parliaments in such fiscal decisions, because they are the connecting element between the people and the budget. I mean, the parliament represents the people, and the people should be in charge of these budgetary political decisions.
Yeah, if I can maybe build on that comment. I think there's two dimensions. The first dimension is timing, and the second one is what needs to be done fundamentally. Now, in terms of timing, I think right now is horrible timing to go in for a fundamental reform of the entire EMU structure and the underlying constitutional nature of the union. The question is, how much time do we have, and how much time can the ECB buy us before there is a revolt? if you take a step back, we're living in the time of Brexit, we're living in the time of populist revolts. There is serious pushback against European integration, sometimes legitimate, sometimes not. But to say this is the time where we need to take a brave leap forward and go for a completely federate economic policy in the Union, I think is very, very, very risky. And just saying every crisis so far has led to deeper European integration is not an answer. That's hoping that it will happen this time around. And part of what we're seeing today is the price we're paying for the leap in the 90s after the Berlin Wall fell. We're still paying that price. So I think it's risky just to jump now. Now, at the same time, something needs to develop because we can't stay here forever. My suggestion would be that, as Frederick said, the founding point, the starting point is democracy. And I think we should start with national democracy. The assumption at some stage was at the European level that we could create European democracy strong enough to support this. So far, that has simply not happened. If you look at all empirical data on legitimacy and on voter support, the primary political level is still national. Now, accepting that means that we need to base also future fiscal integration better on the national level. And that in turn means creating a stronger national democratic foundation for European integration, including fiscal integration. Is that easy? No. It requires a lot of work in many different member states. But if the knee-jerk reflex is, again, let's Europeanize it and let's make the European Parliament more powerful and it will be okay, I think we're in for some serious difficulties. So maybe also to say something controversial here.
If I can take it from there, and I'll leave Eric to conclude on this one. I think the moment of truth is really now. I mean, COVID is the one crisis where we will learn whether we can move forward or not. And the reason is very clear in economic terms. I mean, despite being a very symmetric and homogeneous shock that hit pretty much everyone in the same way, economically, it will generate an asymmetry which is really sizable across countries. And this is due to pre-existing macroeconomic conditions that were there before the crisis. So if you look at the European Commission spring forecast for debt to GDP ratios in 2020, you go from 160% in Italy. I'm not looking at Greece. Greece is an outlier. We know that already. But Italy climbs to 160%. Germany is below 80% in 2020. So you will have a huge divergence, which will, to some extent, undo the massive convergence that we have seen between 2010 and 2019, especially with the macroeconomic adjustment programs in the European South. So once we get there, the ECB surely can buy us some time while we get there, but at that point, there will be difficult decisions to be made necessarily on the fiscal side. One of which I think the most important one will be a discussion about revising the European fiscal framework as it currently stands, because if you look at this level of diversity going forward, it becomes really difficult to see how the European fiscal framework can be appropriate in that kind of situation. So this will be a discussion that will need to be, I think, had at some point, and it will be a very politically difficult discussion to be having. Maybe that is the discussion that will ultimately lead us to take a decision on whether we really want to genuinely move forward towards a fiscal union worth of that name, or to remain in the sort of hybrid system where we centralize part of the competencies, but not the complementary competencies that we would be centralizing in a federal state. I don't think monetary policy can take us out of these difficult choices that will be ahead in 2021, mostly.
Yeah, I just, like I said, I spent much of yesterday and today puzzling through the Dutch government's response to Next Generation EU. And I get the very strong sense from that document, and maybe my Dutch is a little rusty, that the popular enthusiasm for shared fiscal resources at a European level is a little bit low, on the low side, particularly the tax side of this for some reason, but also the spending side. And the framing in the document around conditionality, I think, is going to create a reciprocal aversion, right? Because I don't think that you'll find a whole lot of popularity for conditionality in the countries of Central and Eastern Europe or in the countries of Southern Europe. And so in that sense, I think we really have to ask ourselves, do we want to pick this political fight? And I'm not even talking about, in a moment of crisis, I'm talking about at any point in time. And the reason that I ask that question, I look in the United States and I don't see a whole lot of love for federal fiscal institutions. When I look in Spain, I don't see a whole lot of love for federal fiscal institutions that are asymmetrical. And when I look in Belgium, I don't see a whole lot of love for federal fiscal institutions. So I wonder, maybe there's just something about this. I think Armin made a really good point. There's something about this notion of legitimacy and where democracy is constituted. And Frederick also had that point about the sort of constitutional, what was the term he used, constitutional personality or culture, but I think the implication was that people have different social contracts in different places and they don't really tie up cleanly. And unfortunately, until we figure out a way to reconcile ourselves to that fact, what's going to happen in Europe is they're just going to keep overloading the ECB. And Sylvia, I thought you did a brilliant job in your presentation, basically showing us how we get to the ECB right up to the line. I think the only thing that was missing was, this is not the first time we've been right up to the line, right? Here we're talking about the German Bundesbank refusing to follow the instructions of the governing council by participating in the public sector purchase program. But we were right up at that line when the Irish Central Bank was being accused of extending too much emergency liquidity assistance, when the Cypriot Central Bank faced the same accusation, and most importantly in 2015, when the Greek Central Bank faced that accusation. And cutting emergency liquidity assistance off from your banking community is wildly disproportionate if you're Greece, right? Because the monetary implications of emergency liquidity assistance are tiny. The financial implications of cutting your banks off are enormous. And we've been watching Greece go through that ever since. So if we buy the logic of the German Constitutional Court's reasoning in this context, we have to imagine that constitutional courts in other countries that are under financial duress are going to come up and say, well, wait a minute, did this ECB really think this through from a proportionality perspective? Because it seems like it hurts us a lot more than it's worth in the context of the mandate to provide for price stability over the medium term. And in that sense, I think we're running the risk by delaying this fiscal conversation, which I really don't see how we solve. We're running the risk of breaking the one institution that operates macroeconomically at a truly European level, and that's the ECB.
Thank you. So let me first encourage our audience members to engage with the Q&A. And then let me secondly ask maybe a slightly more technical, albeit also pessimistic question, which is, Sylvia, you've raised the question of the capital key and how the PEPP is deviating quite substantially from the capital key. One of the key parts that I got out of the CJEU's judgment that was challenged by the Bundesverfassungsgericht was first, duration, and second, use of the capital key as checks on possible monetary financing. If both of those are gone, I mean, you've indicated that duration is up for grabs. You've also indicated that in the case of Italy, we have maybe double the capital key being put into play. What happens if this comes not only before the Bundesverfassungsgericht, what happens if it comes, as Frederick indicated that it might, before the CJEU again on preliminary reference, if challenged in Germany?
So actually, that's a very good point that I wanted to mention but forgot. There is one issue that I think is super important in the ECJ judgment, which is the one that is now challenged by the German Constitutional Court. The ECJ, in deciding, in ruling that proportionality is respected, basically says that this is the case because there are some safeguards. So if you read it, the language is really sort of strengthening the value of those limits that are self-imposed because they have been imposed by the ECB itself on its own operations in order to reduce concerns with these programs. And those limits are precisely the limits that the ECB has stated quite explicitly that it intends to interpret much more flexibly going into the PEPP. So the implication is that even though this is a judgment on PSPP, which is a different program, it has it carries forward to PEPP, so it opens the door to legal challenges to PEPP, I think, quite easily, because by saying that the ECB is no longer applying those limits that the ECJ itself says are so important in determining that proportionality is respected, I think that you have a very clean case to go at the PEPP before the German Constitutional Court. So in that sense, then it challenges the validity of the ECJ judgment even more, I think. That said, if I can just add one small thing, in the comment I made on the current share of Italian purchases as opposed to the capital key, it is very relevant, I think, in terms of seeing how the ECB has been operating this program so far. At the same time, the ECB has always been quite clear that its interpretation of the capital key condition is sort of over the horizon of the program. So one could also say this is a front loading of Italian purchases at this point, but then Italy will be underweight for a number of months sufficient for, in the end, at the end of the program, for the share of Italy to reconverge down to the capital key. So in this sense, it doesn't mean that Italy will be at 30% of all its ECB purchases going forward. It just means that for the first 2 months, there clearly was, in the eyes of the ECB, a reason for buying more into Italian debt, but not necessarily this will carry forward. So the requirement is to be seen over the horizon of the program more than over each and every single monthly data that we get to see. There have been deviations monthly in the past as well, even though not as big as this one, but it is something that should be seen over the longer term.
Just to add, if I were the lawyer of the ECB, I would argue that this only shows the increased risk that investors take, because if you have monthly fluctuations, it makes it even less predictable for investors which bonds will be bought. So reducing the argument that this is actually buying on the primary markets as such. Of course, you can only make that argument if there is fluctuation, not if you keep buying month on month on month just from Italy.
Of course.
Yeah, but there's also, I mean, Sylvia's point about the legal basis of the PEP requires that in stock terms, by the end of the program, it adhere to the key. And so they're setting up almost a one-way bet unless they can increase the size of the envelope indefinitely, right? I mean, and this is the real challenge. At some point, they'll have to have a big enough envelope to get back to the stock level at the end of the program.
Or at least a sufficiently big envelope of other countries' debt, which may seem obvious in the sense that one might think I'm out buying this country today, but there is plenty more of other countries that I could buy tomorrow. But with Germany being a very fiscally prudent and strict country, there wasn't actually that much German debt out to buy to ensure that over the horizon of the program, you would reconverge to the capital key. Now, Germany is now going to issue some more debt because of the fiscal stimulus that they're going to do. But up until this was announced, it wasn't so obvious that you had a big enough envelope of other countries, particularly Germany's debt, that would allow you to reconverge even without it continuing to expand the overall envelope of the program.
Fair enough. Thank you for that. We have a broader, I think, more macro question, which is, what is the possible implication in the short term for countries that are eager to join the Eurozone of perhaps both the decision, but also more generally of this situation? And then I realize we're coming sort of toward the end of our time. So I'll just throw in a secondary question as well. And this one seems like more of a statistics question. How likely is a collapse of the euro by growing incapability of the ECB and adverse public opinion? So perhaps everyone can address both questions. And if you want to throw out a percentage, you'll be on the record for having done so. Does somebody want to take the implications for countries that wish to enter question first? Maybe Professor Jones, is that?
Yeah, I mean, the question is focused on Bulgaria. And And I think, once Bulgaria qualifies, they'll be allowed to join. I don't see that as being problematic. As a matter of fact, as Sylvia was suggesting, that would be great, because then the ECB could instruct the Bulgarian central bank to start buying Bulgarian sovereign debt, and that would help smooth things out. It would add to the key. So I think Bulgaria is well placed, provided it can make it through the next 2 years.
And maybe just to add also that besides this entire economic discussion, there's also a political dimension to it. I mean, we saw during the Euro crisis also that the Baltic states were very eager to join the Euro, despite being in a tricky financial situation. So I think there's also a political dimension of binding yourself to the core of Euro. It's not just about this, what the ECB is doing maybe at the moment and what the financial implications are in that regard, but there's also other considerations that might either motivate you or demotivate you to join the Euro.
I think I'm going to take a go at the second one, which is the statistical likelihood of mayhem in I mean, I won't speculate on the statistical likelihood of such a scenario, but there were two potential roads that were mentioned. One was incapability of the ECB, and the other one was public opinion turning negative. I don't think we should worry that much about incapability of the ECB, in the sense that the ECB, I think, is showing still today to be the most proactive and the most forceful EU institution, the one that genuinely does EU monetary and economic policy at this point, as we were mentioning. However, I think what is more worrying is the reason why the ECB is doing this, which is the absence of a political agreement for government to decide on fiscal to take on some of the work that the ECB has been doing for 10 years now. And I think that is especially dangerous because the point we are at right now is the one where you would expect the question of fiscal solidarity to be uncontroversial, because this is the kind of crisis, by being symmetric, by being exogenous, by being in no way related to domestic economic policies of country. This is exactly the opposite that we have seen during the Euro crisis. Is a complete negative of that crisis. So if it was difficult to agree on fiscal solidarity in the previous crisis that we have been through, because it was so charged with implications and consequences and causes that tied into the country's domestic economic policy decisions, it should be uncontroversial now, because this is the one crisis that you would expect to spur this movement towards the agreement around the idea that solidarity is needed in this particular situation. Yet we are not really seeing that. We're not seeing it to be uncontroversial. We're seeing the same controversy that we have seen in 2011 are resurfacing back again. We have the north-south dimension, we have the east-west dimension. Of course, we had this step forward in the Franco-German proposals, but now this has to be approved, and politically we are already seeing that there are difficulties in getting that through the political discussion. So I think this is the significant danger. It is not as much the ECB not being able to rise to the challenge. It is the fact that the ECB has to do so because everything else is basically not doing it. And people clearly see that. And so I think that the biggest danger that we're facing is to not be able to provide this step forward, even faced with the one crisis that naturally would call for it, for an uncontroversial step forward, I think.
And maybe also just to add on that, on the second question, if I had a euro for every meeting I was in where someone predicted the end of the euro, it would smoothen out my own envelope somewhat. Now that doesn't mean that it will never happen, but it has been predicted before. Why do I stress this point? You have to realize that the euro is for many a very political decision. It was a political decision after the fall of the wall. There's huge political commitment behind it. You can see in the financial crisis as well that there was a huge political will to bond it, and we simply don't know what the consequences would be of leaving the euro behind for European integration and for the larger project. Now, one question of me, and a impossible question to the economists here around the table, is whether there is any economically feasible path of reducing the monetary side of the euro without going into full withdrawal, because I sense an increasing interest, both politically and legally, in questions of can we take a step back, because we see that there is huge reluctance to go even further. Immense political capital was extended during the financial crisis to save the euro. There was no capital or intent left to take the euro further to a more stable setup. The logical question that comes next is, if we can't go forward, can we go backward? Usually I hear the answer that it's completely impossible and that you either, pull the rug on the entire construct or you move ahead. So I'm just curious if there's some updated thinking on that.
I think, if you look at what other central banks have been doing, you see the same pattern everywhere. Nobody has been withdrawing. The Fed tried for a bit, then went back in. So the question, I think, is not so much whether it is possible in theory. Of course, it is possible. The question to me is, what do you have to do on other aspects of economic policy to make sure that you can do that withdrawal, or at least like reduction in a way that is not disruptive, not only for the economy, but for the politics of it. Because of course, the stimulus that we have seen has implications on the economics well-being of people in different countries. If you withdraw that, you need to be able to provide something that comes in as a substitution. What is that? That would be fiscal policy, but fiscal policy of that size and magnitude would be very difficult to achieve, even for countries that have a stellar fiscal record and a huge fiscal space. I mean, Germany is showing, I think, right now, what it means to have fiscal space, what it means to have the capacity to spend when you come into a situation where you need to spend. But at the same time, the reason why Germany is able to do this today is also partly due to the ECB's monetary policy, because Germany has been able to finance basically at negative rates for a few years now. And so it has enjoyed part of the benefit that it struggles sometimes to see and to acknowledge from being a member to common monetary policy. But if even Germany, even a country like Germany, if it were to be on its own in this kind of economic shock without the kind of support that monetary policy has been providing, I think would be struggling in terms of providing an equivalent stimulus only via the budget of the government through fiscal policy. I think it would be very difficult for any country in the world. Possibly the only country that can do that is the US, but because of the US having the exorbitant privilege that comes from being the US and the issuer of the US dollar and the US Treasury, but pretty much everyone else, I think, would be in a very difficult position.
Terrific. Well, before we get into the question of decline of global reserve currencies, I think I see that it's 8 o'clock. I want to thank everyone very much for their participation, both the audience and our 4 panelists. Unfortunately, we don't get to the question of infringement procedures, but perhaps that's a discussion for another day. Let me thank also both Susanna and Vittoria very much for their help in setting this up. And with that, I formally sort of congratulate the SAIS Europe community on the 65th anniversary. Thank you very much for joining us, and until next time.
Thanks a lot.
Thank you. Have a good evening.
Bye.
Thank you, everyone. Good evening. Bye-bye.
Bye-bye.